Well, good evening, everybody. Hey, CK, it's Phil from the Chatham-Kent Prosperity Roundtable coming at you through the municipal Facebook page. For those who don't know, my name's Phil Amok. I'm the project coordinator for the Prosperity Roundtable. We're a local initiative down here in Chatham-Kent that works to reduce poverty and help people get ahead in ways that work for them. And of course, part of that is access to decent, accessible, and affordable housing for all in our community. So we decided to work with the municipality and various different organizations across Chatham-Kent to bring you these video series to really talk about what is happening with affordable housing in our community and address the questions that we keep hearing day in, day out from you, the members of our community. The things that you care about, you want to know the answers to, we got those answers for you by inviting local individuals who have expertise, knowledge, and specializations who can provide those answers for you. So I'm very excited to introduce our guest tonight. We have Jeff Wilkins, and he is the housing paralegal over at the Chatham-Kent Legal Clinic. And he is here tonight to talk a little bit more about tenants' rights and responsibilities. And that's a big topic. And before we get into that, I'm going to let Jeff introduce himself, where he's working, and a little bit more about why he's here tonight.
Good evening, everybody. Like Philip said, my name is Jeff Wilkins. I'm a housing paralegal, and I work with the Chatham-Kent Legal Clinic. I've been licensed by the Law Society of Ontario for over a decade, and I specialize in housing law. I've worked with corporate landlords, London Housing, private bar landlords, and also for the Chatham-Kent Legal Clinic. We have a great team at the Chatham-Kent Legal Clinic that can help you try to resolve your landlord and tenant board issues. If you have any questions, please post them, and I will try to answer them as best I can. Thanks, Phil.
Perfect. Thanks for the great introduction, Jeff. So Jeff is here tonight, again, as I mentioned, to talk about tenant rights and responsibilities. You know, this topic has been coming up day in, day out, especially since the pandemic hit. And so, Jeff, I think something that we can definitely want to start with and start talking about is we hear that there's provincial legislation coming out saying, hey, we're going to stop evictions, we're going to prevent them. There's a lot of confusion around, are evictions allowed during COVID? So I'm wondering if you can start with that and give us a couple answers in terms of, are evictions allowed during COVID? Can landlords evict tenants during COVID?
Yes, there was an eviction moratorium, but that ended on June 2nd. So the sheriff is evicting right now, unfortunately, but there is a backlog. That being said, the evictions are moving forward and the government hasn't decided to extend that moratorium. So unfortunately, yes, you can be evicted during COVID.
Okay. And just that word moratorium, does that mean like there was a pause on evictions, or what does that mean? Can you give us some more detail, Jeff?
Yes, there was a pause on evictions when they had the emergency order, just because they weren't quite sure what was going on and wanted to sort out what the housing situation was. So there was a stop. There was still eviction orders going out, but the sheriff couldn't enforce them. But now enforcement is available and sheriffs are evicting.
Okay. And just to confirm, the eviction has to be processed through the landlord tenant board, correct? Or is it just the landlord can just tell you that you're evicted? What's that process?
The only way a tenant can be evicted in Ontario is if they are served with some kind of notice by the landlord. The landlord has to serve that notice and also file it with the landlord tenant board. After they've filed it with the landlord and tenant board, the tenant and the landlord go to a hearing. And at that hearing, the landlord has to convince the board that the behavior was egregious enough or the arrears were way too much that there should be an eviction. Then the board will decide. Then they will write an order. Then the landlord has to take that order to the sheriff, and the sheriff will process it and start the eviction process. The only people that can evict you in Ontario is the sheriff with a court order from the landlord and tenant board. The police will not evict you, and a landlord giving you a handwritten notice or a notice saying you're evicted has no weight to it at all. It has to go through the landlord and tenant board, and it has to be adjudicated, and an order has to be given.
Okay. So there is a process then to this all.
There's a
And
very
so,
long process.
yeah, it sounds like it's a pretty intense process.
Yes.
And so part of this then is questions around what tenants can and can't ask for from the landlord, as in what is their rights as a tenant. And one of the questions we keep hearing that we might see coming through either the landlord tenant board or through your office is, can landlords evict you for asking for repairs to be done?
No, they can't, even though a lot of landlords try to. I do hear from a lot of tenants that have made complaints about maintenance, and the landlord has told them just to get out. Like I said before, there is a process for this, and the only way a landlord can evict a tenant is if they are in rent arrears or if there's been some kind of behavioral issue. And that being said, even if there's rent arrears, they still have to go to the landlord tenant board. An order still has to be given by the landlord tenant board, and they still have to file with the sheriff. I see this quite a bit, and if your landlord does threaten to evict you because you'd like repairs done, please get a hold of the Chatham-Kent Legal Clinic, because there are ways to get around that. And we can talk about that later, but there are applications a tenant can put in to try to get maintenance done. My suggestion for getting repairs done is to send the landlord a text or an email, make sure it's written, so that you can start a timeline. So if you do have to go to the landlord tenant board, you can tell them, I let the landlord know about the problem in January. It's now June and it hasn't been fixed. That way the landlord and tenant board can come up with certain remedies. They can order the landlord to do repairs. They can give you rent abatements if repairs weren't done in a timely manner. So with something like this, I would definitely get a hold of the legal clinic, because there are certain avenues you can go through, and we're more than happy to help.
And so what I heard from that, the sort of the critical crunch of information was, make sure you're keeping a record and communication with the landlord, and make sure you're being respectful, you're asking appropriately, but you're still maintaining that, making sure you're connected with the landlord to say, hey, we need to get this done. And if nothing's really coming to fruition, we're then going to bring it to landlord tenant board. Does that sound about the right process, Jeff?
That sounds right. And the reason why I say get a hold of your landlord, because a lot of times the landlord won't know what he's really supposed to do. So if you get that put in writing, it shows that you're doing this in good faith. You're trying to get these repairs done instead of just trying to sue your landlord. You want to keep that relationship good, because it's a business relationship between the two of you. So I always try to give the landlord a chance to make the repairs and try to communicate that through some kind of writing. That way, if things don't work out, you do have the evidence for the hearing, and you can move forward with the hearing and hopefully be successful.
Mm-hmm. Mm-hmm. You know, I'm really glad you brought up that point about relationships. And I know sometimes with landlords and tenants, it can get really tense. There are some issues that do end up happening in that relationship, in that business relationship. But at the end of the day, it's two people who are coming together in a business partnership. And so respect on either side is really the important part here. It really goes a long way. You know, it really goes a long way having that level of respect for each other, as long as it's given back, I say.
Well, and even if it isn't given back, be the better person, because if you do end up having to go to the landlord and tenant board and there aren't texts being shown where you're calling your landlord names or what have you, the members deal with this at the landlord tenant board on a daily basis. So they can see where you've been respectful and tried to get the work done. But if you're not respectful, they're going to understand why the landlord may be pulling back a bit. So definitely it's a relationship you want to keep in good terms, because you both rely on each other. You need the housing and they need the income. So a lot of times I find if you do reach out to the landlord respectfully, a lot of times they will come back at you respectfully. And if not, you can give the legal clinic a call and we can give you some more information.
Okay. And I see that we do have a question here in the comment section that I want to read out to you. It's regarding, kind of going back to our first conversation regarding the eviction moratorium, or the pause that the province put in, is do eviction the eviction notice process that you talked about, does that eviction process work the same for someone living in an independent living home?
I'm not quite sure what they mean by independent living. Is there any way to expand on that?
It's a good question for whoever posts that comment. Please, give us a little bit more context. We'd love to answer that question for you. I'm imagining that independent living might be related to individuals who might be living with a cognitive or physical disability potentially. It could be for seniors. I'm not sure what that context looks like, but Serenity House. Okay, so we're talking about senior homes, senior independent living facilities, like Tilbury Gardens, or in other senior independent living homes. Does the eviction moratorium or pause also connect to that? And just does the landlord tenant board process also work in the same way for those types of housing situations?
Yes, it does. Independent living homes, if I'm taking this definition right from you, Phil, they are still tenancies and they still have leases that are signed to them. Nursing homes are a different story. So that's where there's kind of a gray area there. But like Serenity House and places like that, they still have a lease and they are still under the RTA. So they would have to still follow the same processes.
And just to confirm, the RTA, that's the Residential Tenancy Act, if I'm not mistaken?
Yes, I'm sorry. I'll stop using these acronyms. That's the Residential Tenancies Act, though.
No worries. No worries. It's one of those things where we live in it kind of every day. So I even catch myself wanting to say LTB for landlord tenant board. So I hear you loud and clear. I think just a reminder, if we take a pause, it's a reminder that, Jeff is here. He's providing some great wisdom and knowledge around housing rights and responsibilities for tenants in the community. If you have any questions or thoughts, please post them in the comments. We do have moderators going through the comments to either answer your questions or post them to Jeff so that he can answer them on our behalf. And please be respectful in the comments, as well as this video will be kept online. So if there are answers that are unanswered, we will try our best to follow up soon with some answers for you. But remember, if you have any thoughts or questions, please post them in the comments. We got your back. We're here to answer them. So, Jeff, if we're kind of going down the conversation around rights and tenant rights and responsibilities, we just talked about independent living homes for seniors, for example, and now we're going to kind of switch gears and maybe talk about the rights for people who are renting rooms in shared living spaces. And so we have a comment here that says, can you explain the rights of people who are renting rooms with shared living spaces as compared to someone who is renting a whole home? So this is more around, they're curious because they might want to potentially rent to post-secondary education students, so they'd be potentially renting a room in their home. So if you can kind of speak to those rights.
They still have the same rights as any other tenant if they're living in a high rise or if they're living in a house, as long as they're not sharing a kitchen and a bathroom with the landlord. They still have the same rights. What I see with a lot of student housing is the landlord will have students sign separate leases for the house because they are renting the rooms out, but they still have the same rights and responsibilities as a regular tenant would. And the landlord still has the same rights and responsibilities for repairs, for evictions, for stuff like that. A lot of people are under the impression that if you rent from a house that's renting to 7 different students, they're not covered under the RTA. That's not the case unless it's residents at a university or a college. Those are used for primarily temporary residences, so they're not covered under the Residential Tenancies Act. But if it's a bunch of people renting a house and a bunch of rooms, they're still covered under the Residential Tenancies Act.
And so something you said there really caught my ear, and it was if the landlord and this individual, even if they're renting just a room, as long as they're not sharing a bathroom in a kitchen, they're covered under the RTA. But what if they are? Say, for example, I have a home with 3 bedrooms, I'm using 2 and I rent 1 out to anybody in the community, and they share my kitchen, my living room, they share all spaces at the house. Is that the same? Do they still have are they covered under the Residential Tenancy Act?
So you're a tenant and you're renting out a room in your apartment, is what you're saying?
Exactly, yeah. So let's just say I own my own house.
Mhm.
I own my own house and I want to rent out a room to help out a post-secondary student, or maybe a neighbor down the street is going through some tough times. I can rent out a room, but they're sharing my entire house with me. They're not in a separate, granny suite or separate part of the building. They're in my house with me. Is that considered a tenancy, or is there a different definition for that?
Unfortunately, if you're the landlord and you are renting a room out to somebody, you don't have any rights under the Residential Tenancies Act. You are considered a boarder. Now, that being said, if you're a boarder and you've paid your rent for the month of June and the owner of the house gets sick of you the first week of June and wants to kick you out, you're still covered. You're still covered because you have signed a contract to rent that room for that month. So even though you don't have rights under the Residential Tenancies Act, you do have certain rights under the Commercial Tenancies Act that say, since you've signed this contract, you're allowed to stay till the end of that contract. But other than that, you don't have many other rights whatsoever.
Mhm. So just to be clear, just so make sure our audience understands, if you're the landlord, you could be an owner of your own home or a landlord of a building renting out part of a suite in the building. If you're the landlord and they're sharing all the same spaces as you, it's not covered under the Residential Tenancy Act. It is considered boarding, and it's a private contract. But if they live in a separate part, even if you're a landlord, if they share a different part of the house with their own kitchen, their own bathroom, it's an own separate unit. Even if it's your own house, you kind of maybe separate your basement into its own apartment. That would be considered a tenancy, and they would have rights under the Residential Tenancy Act, if I understand that correctly, Jeff.
As long as they don't share a kitchen or a bathroom with the landlord, they would be covered. Now, one thing I do see happen quite a bit is some landlords will say, I live here, but they only show up once or twice a month. The landlord, for them to say that you're a boarder, that has to be their principal residence. If they're just showing up there for 1 or 2 days a month, they're quite frankly trying to get around the Residential Tenancies Act, and that won't go well at the landlord and tenant board because it has to be their principal residence.
Okay, that's a really good piece of information. So if somebody finds themselves in that situation, what would you recommend? Would you recommend them giving you a call or giving the Chatham-Kent Legal Clinic a call, if that's the case?
Definitely. If you have any questions to do with landlord and tenant board, or even boarders, let us know, because each situation is different and has different moving parts. So it's kind of difficult to answer without knowing exactly what the situation is. So please phone the legal clinic. That's what we're there for. And quite truthfully, when COVID hit, we got so busy that we've allocated other staff at the clinic to try to help out with some of the housing questions. So we have a very full staff that are very knowledgeable on this. So please call us. That's exactly what we're there for.
Exactly. You took the words out of my mouth. That was kind of my speech, Jeff.
That doesn't happen very often, Phil.
Right. I have to say to everyone who's listening, Jeff and his team over at the Legal Clinic, and including Walter Vanderkloot, the executive director over there, they are an impeccable team. They really are an amazing team. They're huge advocates for this community, huge advocates for every client they work with. So they really can earn your trust right off the bat. So they're a great team to connect with if you have any questions, or you're facing some challenges as a tenant, and you have some questions about the landlord and tenant board or other rights and responsibilities as a tenant.
That's what we're there for. So please use us.
Exactly. Fantastic. And so we have another question that came in as well, and we might have to seek some clarification, but I just want to word it out there in case you know what I'm talking about. So we have a question that says, the rights of tenants when the landlord, what are the rights of tenants when the landlord sells the building and the new landlord wants the rental units to be empty? So say I come in, I buy a big apartment building, and I want to clear out all the units and do with them what I want. Or do I have any rights if I'm a tenant in that building?
You have an incredible amount of rights. If that landlord is not moving into the house, or let's say it's a house that you're renting and the landlord has bought it, but he's not moving in, that's called conveyance of land in the Residential Tenancies Act. And what that means is the new landlord inherits everything, inherits the tenant, inherits the old lease, inherits the last month's rent, and inherits the proper rent that the tenant is paying. So if somebody buys your place and they're not moving in, they can't increase your rent. They can't ask you to sign a new lease. They can't ask you to change anything because that old lease and all the rules with it move to the new landlord. I do see this quite a bit, and guess I can't blame landlords for trying it, but I would definitely, if you see this, give us a call, because you have all the rights in the world to be able to keep this tenancy the way it is after the new person has bought it. And quite truthfully, the person that buys it, if they're educated enough, should know this. And if not, they need to get some legal assistance, because this is a very common thing that happens with landlords. A lot of properties do turn over, but you definitely do have all the rights you had with the last landlord, and you don't have to pay extra. You don't have to sign a new lease. You have the same tenancy you did with the old landlord.
Okay. And so just kind of following up on that piece, what if this new landlord comes in, has purchased the property, under the conveyance rule that you just mentioned, they inherit everything, including the lease and the tenants living there, but they show up one day and they say, you know what, I'm moving family in here. I need to evict. What are the rights of the tenant? Is that allowed? Can you kind of give us some more information on that?
This happens quite a bit, to the point where the Landlord and Tenant Board have changed the rules last March. And I'll get into that after I answer the question. If a landlord is having a family member move in, they have to serve you with a notice with, as they call, an N12. And that's for a landlord's own use or a purchaser's own use. Now, they have to serve this to you on the last day of the month, and they have to serve it to you, giving you 60 days notice. Now, this N12, and quite frankly, most notices look pretty scary. There's a big black banner on the top of it that says you could be evicted. There's a termination date that says, I would like you to move out. But the language is the telling part of this notice. You could be evicted, and I would like you to move out. That notice is the same as any other notice. They have to file it with the Landlord and Tenant Board. And if you don't want to move out, you have a right to a hearing. So you can wait till the hearing and see what kind of evidence the landlord will put forward saying that the person is moving in. Now, they also have to file a affidavit right now. That's going to change in September, but they have to file an affidavit, and they have to file it to the board, proving that this is moving forward. One thing I do tell tenants, if they do get an N12, is sit on it for a couple days and then phone the Landlord and Tenant Board and see if that's been filed. Because the chances are, if the N12 hasn't been filed, and you'll need to keep checking up on this, but if it hasn't been filed, the chances are the landlord's just seeing if you will move out because that notice looks so scary. I've seen at least a third of people that get these notices move out because they think it's an eviction notice. It is not. And I'll reiterate what I said at the beginning. The only way to be evicted is to have your hearing, and for the board to write the order, and for the sheriff to enforce it. So if you do get one of these, my advice is to get a hold of the Landlord Tenant Board and see if they filed it. If not, keep getting a hold of them, but also keep your ear to the ground for any kind of units that are coming up, because there's a 60% chance, I would say, that this is a legitimate request by the landlord. Now, that being said, that means there's about 40% of these that are not true. They're just trying to get you to move out. That's happened so much that the Ontario government has changed the laws with Bill 184, stating that if you do move out because the landlord says his family member is moving in and you find out they haven't, or you find out they haven't moved in for a year, which is what they have to do, the landlord will owe you 1 year's worth of rent on your new rental price. So they've really upped the ante on this because they see it happening quite a bit, and that's because of the real estate market. Now, with the N12, for the termination date, they also have to give you 1 month's worth of what your rent would be. And this is consideration for you having to move out. They have to
Well, looks like everybody. Looks like our keynote speaker for the evening, Jeff, has frozen on us right now. So I keep imploring everybody to keep sending your questions and comments in. Jeff should be back quite shortly. We might have to take a little bit of a break before Jeff comes back in, but I think it's important that we carry on the conversation in some capacity. By no means am I Jeff Wilkins. I don't have all the answers to everything around housing. But I think it's important that we do carry on some level of a conversation. So if you have any thoughts, throw it into the comments section, into the question section, and I'll be sure to get back to you as soon as possible when Jeff joins us again. Right now, when it comes to housing in our community, if I can kind of have my little moment to speak, I guess. So what's happening with housing in our community is, to many people's question, it is a challenge. We have low vacancy rates, which means that for the amount of rentals we have more people who are looking for housing than we have affordable rental units, or units that are within people's price range. On top of that, the market prices for affordable housing and just housing in general has really skyrocketed. And so what ends up happening is you kind of have this challenge where on one hand you have not enough housing for the amount of demand out there, and you also have huge prices. For example, I know some people were posting pictures of yesterday on various Facebook pages as I was doing some research, and I saw various people posting pictures of ads for 1-bedroom or 2-bedroom housing units that are hitting into the $1,500-$1,600 range. For individuals who are on lower or fixed incomes, or even working near at minimum wage, even for those who are working with a solid, stable wage, that's a significant amount of money. And so I would like to have a quick conversation or share a little bit about why it's so important to talk about affordable housing. In our community, there is a spectrum around housing. In any community, there's a spectrum around housing. You kind of have the rent geared to income housing, and that is really different from affordable and market rent. And I think this is what gets confused sometimes. Rent geared to income housing is a type of housing that you're paying 30% of your income towards that housing unit. So those are really for individuals who might have a very low level of income. It's really a great way to make sure they're housed and still have financial stability to be able to access food, to make sure they can eat, make sure they have clothing, and various other pieces of their life. Make sure that they're housed sustainably and stably. Affordable housing is not the same as rent geared to income. Affordable housing, you're paying 80% of market rent. So the difference being, again, market rent, you might be paying $1,500 at market rent. Well, 80% sitting somewhere at the $1,250 to $1,300 range. That is what you're going to be paying in an affordable rental unit per se. So that is the difference there. And then you also have market rent, which is just your typical most people who are renting are market rent because they're going to just find whatever is available out there. So why I want to speak about that spectrum is because when we advocate for more affordable housing, more rent geared to income housing, it is because we have more and more people who are facing situations where they are being evicted, where they are being priced out of the market. And this is regardless of walk of life. People from all walks of life are being placed in a position where they're struggling to find housing that they can afford. And for the federal government and for Canada, what the measure of your ability to afford a home is, are you paying more or less than 30% of your income? So if I say to you, are you paying less or more than 30% of your income? Then what that means is, you say, for example, you make $2,000. If you're spending more than 30% of your monthly income on housing, you are actually in an unstable housing position. And what that means is that because you're spending so much on your housing, it's taking away from your other needs. So the goal is, in our community, for any community, is making sure housing, yes, we have to have market rent. That's important for a lot of reasons, but we also have to have affordable housing. Because if we don't, people get priced right out, and we see a cascade of issues jumping in, cascade of issues happening. So we want to advocate very heavily for affordable housing. And what I have right now, and I'll get off my soapbox, I've been talking for a couple minutes now trying to stall, honestly, but hopefully this information's been important and really relevant to everyone on the call. It's important we talk about this. So what I'm going to have is I'm going to actually have Jeff's colleague, as Jeff is getting back on the line, I'm going to have Jeff's colleague, Rashin, join us. Rashin, thank you so much for jumping in. I really appreciate it.
Hi, Phil.
Perfect. Thank you so much for joining. We really appreciate it. And we do have a couple questions that came in while we were chatting. So one of the big questions that jumped in is, what should I do if I don't like my neighbor? Like, what if the neighbor is threatening me or potentially damaging my property, like my car outside, they're throwing eggs at it, or who knows what they're doing, but they're damaging my property? What can I do about that? Can the landlord tenant board do anything about that?
That's a great question, and we do get that at the clinic often. I should say that I'm one of the staff lawyers at the clinic, and I work with Jeff, and I just thought I would jump in while we get him back on the line. With regard to issues with your neighbors, if we're talking about neighbors who are tenants, so you are a tenant of a building, and the neighbor that you're having the problems with is also a tenant, you do have certain avenues and certain remedies available to you. So as a landlord, not only do they have the responsibility to make sure that the unit is habitable, that they do the repairs, but they also have a duty to make sure that you are safe. They have a duty to make sure that you're able to have reasonable enjoyment in your own home. So that extends to the physical safety and the structure of the building, but also with regard to your relationship and interactions with other neighbors and other tenants. So if you do find yourself that you are a tenant in that circumstance where there are issues with a neighbor that you have, then my suggestion to you would be to make sure that you inform your landlord of the problem and to also document what is going on, because that is very important. Because the landlord tenant board is there to make sure that everybody is treated fairly. That is their duty. So as part of that, they have to make sure that if they're going to decide to evict somebody for their poor behavior because it is causing threats to somebody else's safety or reasonable enjoyment, they have to make sure that they're doing it in a way that ensures that everyone's rights is respected. So as part of that, they have an obligation to make sure that if there are any allegations against somebody, that those are substantiated, that there's evidence. So the evidence would be in the form of who was it, what did they do, when did they do it, toward whom. So it would be all the types of details that you would expect in any case where you were accusing somebody of having done something. So if you have the documents, if you're writing down all of these details, that is what will be helpful in trying to determine the next steps. And if eviction is on the table, and if it is going to go that route where the neighbor that is causing the problems is going to be evicted, the landlord and the landlord tenant board will rely on that evidence to make that decision. But ultimately, with you as the tenant, your responsibilities would be to inform the landlord, and if you do have details, to provide those details. But then ultimately, it is the landlord's responsibility to take action to make sure that you are safe and that your rights are respected.
So a big part of what you just said, Rashin, is really documentation. It is really critical to document the evidence, taking pictures, writing dates, times, what was said, how it was said, all those different pieces of the puzzle, because as you said, it's going to be relied upon as evidence if an eviction process is started through the landlord tenant board for this individual. If I heard that correctly.
Exactly, yes.
Fantastic. Okay. I hope that answered the question for those who were commenting on that. And I have some more questions, actually. I'm just going to scroll up here because I know there was a couple that popped in. So when it comes down to housing in Chatham-Kent. There is, as I was kind of talking about before you jumped on, there's a lot of challenges right now. And so one of those challenges is someone was asking, if a tenant can't find a place in 60 days when they receive that N12, can they request an extension? And just if you can just remind everybody what an N12 is again.
For sure, yes. An N12 is a notice that a landlord would give to a tenant saying that either themselves, a close family member, or somebody who's purchasing the property, the new landlord is planning on moving in, or their immediate family is moving in. And before I get into the details about the 60 days and whether they can have more time, I should mention that, again, if you do get that N12, please do your research and please do reach out to us, as Jeff mentioned, because there's very, very specific criteria which have to be met. One of those being, for example, it can't just be any family member who is expected to come in to move in. There's only very specific family members who are allowed to benefit from a notice such as an N12, which would basically result in the eviction of a tenant. So it can't, be, for example, my aunt who wants to move in. It's a spouse, it's a child, it's an in-law. So there's very specific ones. So again, do your research. Please do reach out to us, because in addition to that, there's certain other details which have to be there in order for that notice to be valid. Now, with regard to the question of the 60 days, the 60 days, I would say a lot of times it can be negotiated. And like Jeff mentioned, in other contexts, a lot of times if we're able to, I see Jeff coming back. So I will just finish answering and hand the mic back to Jeff. But with regard to the 60 days, I would say that there's definitely room for negotiation with your landlord, whether it be with an eviction such as this, such as an N12, but with others as well. Because like Jeff mentioned, you want a place to stay, the landlord wants their rent. So if you can work something out, almost anything is negotiable. And if you're able to have that conversation, keep those communications open and negotiate time and date that perhaps works for both parties, compensation that works for both parties. That's another element that is important. By law, there is compensation which could be due to you if it is the result of an N12 that you're moving out. But perhaps there's more room for negotiating that dollar amount or paying for moving expenses, for example. So again, do have that conversation with the landlord. And with that, I will log off and let Jeff take over.
And thank you so very much, Rasheen, for all your time and all your great wisdom. I appreciate it. Welcome back, Jeff. Thanks for leaving me high and dry.
Thanks,
I'm glad Rasheen could, no worries at all. I'm glad Rasheen could jump in. That was fantastic. She provided some great responses to some of the questions coming.
It actually brings up something I wanted to talk about anyway, is the hearings that are going on virtual. And a lot of times this happens virtually. So it was just a weird wrinkle there that all of a sudden I got booted out of my own virtual show, I guess. But I apologize for that, Phil, and thank you very much.
No issues on our end whatsoever. This is part and parcel of the fun of doing Facebook Live. Something always which is going to happen, right? No worries at all. And so before we jump into the next comment that we see on here, I really wanted to just touch base on a couple pieces. Can you confirm the services at the Chatham-Kent Legal Clinic where you work and Rasheen works and others work doing this housing paralegal stuff? Is it cost? Is it free? Can you give us sort of an idea of how that service works?
If you are on some kind of assistance, the service is free. If you're not, there is a threshold that you have to be below. I believe it's not a very big threshold. I believe it's under 30 grand, but you can phone the legal clinic and we will let you know what that threshold is. But quite truthfully, if you do phone up about a landlord and tenant board issue, I'm going to help you. You're not a millionaire if you're renting, probably. So I can at least give you a little bit of summary advice. I won't be able to go the full 9 yards kind of thing, but I'll never gonna say no, I can't help you out if you're a tenant. But we do, most of our services are free, and I will run through our services again at the end just so that you know. I just didn't want to didn't want to muddy the waters with what else we do, because we do quite a few services. So if you can remind me 5 minutes before we stop, Phil, I'll let them know exactly what we do. But yes, you're correct. Most of our services are free. And if we can't help you, sometimes we can point you in the right direction. It's always a good idea to give us a call, because if I can't help you, maybe I know a partner in the city that can help. Because the very cool thing about Chatham-Kent is the partnerships work together very closely and very well. So definitely, if you need to phone us, just phone us. We'll worry about that.
Okay. So moral of the story, yeah, just phone, no questions asked. Give us a call, and we'll work on it together and figure it out together.
We'll work on it together. And if you're above the threshold, we may not be able to help you, but give us a shot anyway. We'll point you in the right direction.
Fantastic. Thank you, Jeff. I just wanted to clarify that piece. And before we jump back into the comments, I just wanted to also mention that we have about 15, 20 minutes left of the live. So if you have any questions or comments, make sure to get them in so we can answer them before we hit up 7:30. And lastly, before we get back to it, if you have any thoughts as listeners, viewers, people asking questions, posting comments, if you have any thoughts about what future videos of the Ask the Expert series could look like, please drop us a line, give us a call, shoot us a text, however it works, or shoot us a private message. We'll be happy to learn what you think would be another great Ask the Expert panel discussion. So thank you very much for joining today. So back to the comments. We have a great comment here. I really like this comment because it's actually going to add a lot to the conversation, I think, and answer some questions I know we always get on a regular basis. So what happens if you manage a property and a disgruntled tenant who's no longer a tenant anymore, but they're coming back, they're threatening management, they're threatening other tenants? What should you do? And can you do anything to maybe trespass or restrict them so they can't come on property? What does that look like? And does anything happen to do with landlord-tenant board in that situation?
If this person's no longer a tenant, he has no rights to that property. If he has a problem with what the landlord did in the past, the tenant has up to 1 year after he's left the residential unit to go to the landlord-tenant board and try to get remedy from the landlord. But if he's not doing that and he's just showing up, definitely phone the police, because he doesn't have any rights to that property. And if he's disgruntled and he's taking these actions, I'd go on the safe side and give the police a call. He has no rights to be on that property. He is not paying rent anymore. So I definitely would get the police involved and tell them the full story. Tell them he used to be a tenant and he's disgruntled, and now he is he's harassing the property manager. There are options for that disgruntled tenant to move forward with something. So again, I would say get a hold of the clinic, because if it is within the 1 year limitation period and he does have a legitimate gripe with the landlord, we might be able to point him in the right direction. Normally we won't take on full files. We do take on some full files, but with the increase that we have with the amount of tenants that are phoning us, and we also do tenant duty counsel, it's very difficult for us to take on files. But if it's something pressing and something with merit, definitely get a hold of us, because we're going to do what we need to do. And if we need to take this file on and get retained to try to get the proper remedy, we will do that.
Okay. Fantastic. So just so I understood that, what you're kind of saying is really it comes down to two situations. If they have a legitimate claim, this previous tenant can go to the landlord-tenant board and work with your office to navigate that process. But if they don't have a legitimate claim, or they're causing disruption or issues, the landlord has the right to phone the police and ask for a trespass order to be issued, so that they're not able to come onto that property, if I understood that correctly.
And that's something they'd have to deal with the police with. The RTA does not, the Residential Tenancies Act does not apply here, because they're not a tenant anymore. And the Residential Tenancies Act only applies if you are a tenant or a landlord. So it doesn't apply before you're a tenant. If you were to sign a application to get into a building, you're not a tenant until you sign that lease. After you've signed that lease, you have coverage under the Residential Tenancies Act.
Okay. Okay. And then we have some questions also coming in as kind of going back to repairs. It seems to be a topic popping back up again. Before we jump there, though, I just want to clarify. You said tenant duty council a couple of times. Can you just clarify what that means? What does that mean?
In Ontario, most jurisdictions have what they call tenant duty council, and tenant duty council are run out of the legal clinics run by ACTO, the Advocacy Center for Tenants Ontario, and we'll put their information up later so that you can see it. But what I do as tenant duty counsel is I'm there at the hearing to give free, brief legal advice to any tenant that needs that advice. Sometimes we will go as far as representing them at the hearing, but I'm there as tenant duty counsel to help everybody. During in-person hearings, there were about 30 people on the docket, and we would have about 15 people on average that would ask for tenant duty counsel help. So we're there to give free, brief legal advice. If we can represent, we will. But with the volume that we have, it makes it very difficult the day of. So if you do have a hearing coming up, you will get a notice of hearing from the Landlord and Tenant Board. Let us know, because if I know and I'm tenant duty counsel, I can make sure that I'm there the day of the hearing as tenant duty counsel, and I can give you whatever advice you need. And quite truthfully, the members really want us to be there to help out because it speeds up the process. So please don't be afraid to ask for tenant duty counsel help. We're there, and quite truthfully, with the way that hearings are going now via Zoom, there's quite a few tenant duty counsel there because the dockets are pretty big. But if you phone the clinic and let us know that you have a hearing coming up on such and such a date, we will phone you back. We'll get the information from you. We'll try to help you out beforehand. But there will also be tenant duty counsel there, myself or Rasheen or Melinda, that will be able to help give some free summary advice, because things get a little hectic the day of, and sometimes you need a little reminder, and that's what we're there for.
Fantastic. Thank you. I'm glad we had that conversation, because tenant duty counsel, I think people might assume it's kind of like similar in criminal court where you have duty counsel. It's the idea that it's publicly provided and they're there to provide that support. So I'm really glad that you mentioned that piece.
And that advice from tenant duty counsel is free, and it's also confidential. So normally, nowadays we will go into a separate Zoom breakout room and I'll give you your advice. And normally when I give advice, I will also go back into the hearing to make sure that things work out all right. The members, and that's what they call the adjudicators at the Landlord and Tenant Board, are members. They want tenants to be informed. So they will bend over backwards to try to get that tenant to tenant duty counsel if they need the help. So please use us.
Fantastic. I'm glad that you mentioned that piece about the confidentiality and the free service of tenant duty counsel. That's great.
Now, I did see one thing in the chat that I kind of want to address, Phil.
Yes.
The question was, if you do have repairs, how long does the landlord have to make those repairs? Did Rasheen answer that?
I don't believe so. I believe that's still a question. Oh, but I actually just took it right out of my mouth. I was just about to ask that question. So how I understand the question, and you might have a different sort of interpretation, but I'll throw it out there. I think where that question was coming from was if I move out of my rental unit. So I'm a tenant, I move out, I'm in a different tenancy, but then months down the road, I get a bill from my previous landlord for a carpet replacement or for some fixings that happened after I moved out. Can I go, do I have to pay it in full? Can I go to the Landlord Tenant Board and dispute that? How does that process work?
This is going to change as of December 1st of this year. Right now, if you move out of a rental unit and your landlord has not filed against you for repairs or for rent arrears, they've lost out. You're no longer a tenant, so they can't go to the Landlord and Tenant Board to try to get those repairs. They can try to go to small claims court, But that's a different animal, and that's a lot tougher and a lot more expensive and a lot more time consuming. So a lot of landlords don't follow up with that. Coming December 1st, a landlord is allowed to go after a tenant after he moves out of the rental unit. So they will be able to take you to the landlord and tenant board and ask for those repairs. Now, that being said, if they're complaining the carpet was messed up or there's dings in the wall, carpets have a certain life expectancy, and I believe that's 10 years. And a person living in a unit, there's going to be damage that's caused by just living. So reasonable damage in a unit, normally you shouldn't have to worry about. If you do end up causing a lot of damage, the landlord probably will try to come back on you. But if you move out before then, they can't do anything right now, but that will change December 1st of this year. Now, what the board looks at for landlords doing repairs and the amount of time is, let's say you have a leaky roof and you notice it January 1st, you tell the landlord and he doesn't repair it until June 1st. The landlord tenant board takes a look at what the damage, what the maintenance issue was, when you let the landlord know, because you have to let them know right away. And then they figure out when you let the landlord know and when the landlord repaired that, was that a reasonable amount of time? And the key word is reasonable. So before COVID, if you had a leaky roof, getting it fixed within a few months would be a reasonable amount of time. During COVID, when they didn't have a lot of contractors out there, it was taking double or triple the time. So the test they really go on is, was the amount of time it took the landlord to do these repairs reasonable? And if it was not, there could be some kind of rent abatement given to the tenant.
Okay. So good to know. So the rules will be changing. So we're going to probably keep an eye on that and maybe do an announcement as we get closer to that change. So we're making sure that we are keeping the community informed. So I really appreciate that. I didn't even realize that the change has come.
As soon as the rail ascents happen, there will be one in September and one in December. I will send the information out, and you can send it to the partners.
Fantastic. And we're getting close to 7:30, so I know there's a couple more comments in there. I'm going to try and get to as many as I can. So I do have another question for you, kind of around repairs, what is the property management's responsibility to do repairs during COVID, specifically outside the home? Or inside, I mean, it doesn't really matter if it's inside or outside, but what's the property management's responsibility to do those repairs?
Well, that's going to change very shortly because the stay-at-home order is going to be lifted, and hopefully, knock on wood, it won't be extended. In-home repairs were a problem during COVID because a lot of contractors did not even want to go there. So the landlord and tenant board has given them, has said that it's reasonable during COVID to take a longer time. That being said, if you have a leaky roof and it only has to be repaired by the outside, there's really no reason to drag your feet on that. Doing repairs and maintenance work right now is pretty difficult for landlords because a lot of contractors are either not working in units that they don't know if there's COVID or not, or else they're building new houses. So there's a lot of contractors that their time is being used up, and it still goes to the reasonableness. Is it reasonable to take this amount of time? Now, if you're a tenant and you think that it's not reasonable, please get a hold of us, because a lot of times we can give the property manager a call if it warrants it and say what's going on. But what I would suggest with stuff like that is write the property manager, email them or text them so that you've got it in writing so that you can use that. If they do drag their feet, you can move forward with a tenant application for maintenance.
Okay. And kind of building off that relationship, I know it always comes back to that tenant and landlord relationship and respect between both parties. And so kind of building off that, there's been some questions in the chats coming up around like tenant groups and tenant associations, or tenant meetings that happen among the different tenants in the building. What are tenant associations? What rights do they have in organizing, and can property management and landlord inquire about who attended, what they talked about, those types of rights of the tenants association?
No, the landlord really can't inquire about that. They can ask the question. There's nothing stopping them from asking, but quite truthfully, it's none of their business. It's like having a chess club at an apartment building. Do they want to know who's in the chess club? No, because it doesn't affect them. Are they a little nervous about a tenant association? Probably, because they know that they're going to be called to task on some things. You will get some pushback from landlords. What I would suggest, if you are going to start a tenant association, or if you are in one, don't be adversarial with the property manager. Tell them what you're doing, and if you want to post notices, ask them if you can post notices. The one problem a lot of tenant associations get into is they become very adversarial at first because they're fed up, and that's understandable. That's why the association has happened. But you still want to keep that relationship with the property manager and the landlord, because you catch more flies with honey. As soon as you start being adversarial, they're going to put their guard up, and they're probably going to ignore what you're saying because they don't want to have any legal liability. If you are having enough problems that you need to start a tenant association, give the clinic a call, because sometimes we can be the intermediaries. Sometimes we can come to a meeting with you guys and with the property manager and hash stuff out. That's where we always start. We never start with a lawsuit. We never start with being adversarial, because in these days and times especially, we need these relationships to be a good relationship, because the worst thing you can have is a landlord and tenant that don't get along. Landlord's not enjoying themselves, the tenant's not enjoying themselves, and it becomes what we call a poison relationship, which nobody wants. So if you are having these problems, get a hold of us and we can try to help out. That's what we're here for.
Fantastic news. I mean, that's big, because I think when it comes down to it, a lot of tenants have a desire to really learn about their rights and their responsibilities, but more importantly, understand that they're not alone, in that there's a ton of questions being asked about what's going on, what are my rights and responsibilities, and knowing that you have individuals to connect with who might be able to share those answers or share in their experiences so you can figure out some solutions together. That's a great thing to have in a tenant association. And I think sometimes people might feel a little bit intimidated, when people are asking questions about what's happening in the group. But I think you just answered very well that you can always be that intermediary. You can be the intermediary and sort of bridge that gap between the two parties at the table sometimes, which I think is a really important piece for moderation, eh?
And a lot of times, all it takes is a phone call from the legal clinic saying, look, we have this situation. We want to try to clear it up. How do we do this? And a lot of times the landlord is more than willing to. They're just not sure of the process. They're just not sure of, okay, am I all of a sudden in a fight with this tenant that I need to watch my legal rights on? If you get us involved, I can, or we can have a very candid conversation with the landlord saying, look, we just want to solve this problem. We don't want to create any kind of headaches for the tenant or for the landlord. We're here to try to help. So if we can be an intermediary between the two parties, we're more than willing to do that. It just makes perfect sense for both parties. If I can talk to a landlord and a tenant and say, I understand, but this is the law, sometimes the landlords don't understand that, and they're thankful to know it. Believe me, I'm not going to be adversarial if I don't need to, because that's not the way I work, and that's not the way to keep relationships growing and flourishing.
Absolutely. No, absolutely. I think that's a very good takeaway among the many that happened today and tonight. One of the biggest takeaways is definitely that we want to maintain those relationships as much as possible, because, as the saying goes, you catch more bees with honey than vinegar. I think it's how it goes. So it's always nice to have those relationships be maintained if possible. yours. And so we're kind of coming to the end of the conversation tonight, ladies and gentlemen.
All
And
right.
so
Wow.
it has been an unbelievable conversation, Jeff. Really, this has been very valuable, I think, for everyone in our community to understand a lot about their rights, responsibilities. And I think, as you could potentially agree, these conversations are not easy, and they're not a simple answer all the time. There's a ton of different factors at play that really you have to consider when working through tenant rights and responsibilities and landlord-tenant board.
Every situation is different, and that's why it's hard to give vanilla advice over this stuff. But that's what we're here for. We've got a very good clinic with a very great partnership. I deal with so many people in Chatham-Kent, our partners, that I can't do what I do without having those partners there. So give us a call, because if we can't help you out, we've got partners that will try to help you out. And believe me, the partnerships that we have in Chatham-Kent, every one of them that I deal with care, and they bend over backwards to try to help people.
Mm-hmm.
And just to let you know what else we do at the Chatham-Kent Legal Clinic, because a lot of people don't realize what we do. Of course, we do landlord and tenant matters. We also do Canada Pension Plan appeals, Ontario Works appeals, ODSP appeals. We have an employment lawyer that works between 3 different clinics. We also do human rights. We do criminal injuries compensation. At times we do wills and powers of attorney, but right now, because of COVID, that's a little difficult to do. But in case of emergency, we will try to do that. And we also do small claims court when we do have the time to do it. Right now, our clinic also has a program going on with, 21 different legal clinics in Ontario called SHU, Sexual Harassment in the Workplace. And this is funded by the Department of Justice. So they're taking this pretty serious. And what they do is they provide free summary advice. So if you have summary advice you need, you can get a hold of them. And they do workshops. They can also get you in contact with other clinics that do sexual harassment in the workplace hearings. So they will be able to set you up if you do get a hold of us. And like I said, all of these services that we provide are normally free. And if you just give us a call, if you're not quite sure, that's the best thing to do, because we're going to, like I said, we're not going to turn you around and say, get out. We're going to try to send you to who we can send you to. We are affiliated with Legal Aid. A lot of people think that we are part of Legal Aid. That's not true. We are a legal clinic, and we do have some funding from Legal Aid, but we're a legal clinic. And the main difference between us and Legal Aid Ontario is Legal Aid, for a lot of their things, requires certificates. So you have to apply for a certificate to get help from a lawyer. With the legal clinics, you just give us a call. You don't need a certificate. You give us a call and we'll do what we can to help you. So just wanted to point that out, because a lot of people call us Legal Aid Ontario, and they're a totally different entity. They're good at what they do, but we're also good at what we do, and we're separate, and we're a little easier to access. So I wanted to point that out.
Fantastic. I really appreciate everything you've brought to the table here tonight, Jeff. I mean, this has been a wealth of information shared with our community. I've certainly learned a heck of a lot, because I know I had a lot to learn. So I'm glad that I was here to able to facilitate this conversation. I hope everyone who has been commenting and questioning in the comment section on Facebook and YouTube, I hope your questions were answered effectively. And as Jeff was saying, if you have any more, or you have a follow-up question, please do not hesitate to reach out to the Chatham-Kent Legal Clinic. We do have moderators who are following through the comments. They're posting the phone numbers for the legal clinic and for other organizations, agencies in their community and at the provincial level to help out if you have any questions. I will be monitoring the chat after this call. So I hope everyone can please raise a nice hand for Jeff and give him a clap over the comment section. Please thank Jeff for his amazing expertise and time brought to the table. And again, if you have any thoughts on any future ideas for Ask the Expert panel discussions, please put them in the comment section. We're going to be checking it over the next couple of days to see what ideas you have, because we want to bring your answers to you. So we'll be talking soon, Chatham-Kent, and I hope everyone has a great night. See you for now.